Welcome back to Spaulding Injury Law Podcast. I'm Abby, and today I'm here with Ted Spaulding from Spaulding Injury Law. Good to have you back, Ted. Thanks for being here.
Yes, thank you for having me.
Today we are getting into the thing that can make or break a car accident case here in Atlanta, the evidence. Most people think of the police report as just paperwork, but in a Fulton County case, the quality of that report and the evidence behind it often decides whether someone gets fair compensation or walks away with nothing. We are going to break down every type of evidence that matters: police reports, photographs, witness statements, video footage, medical records, expert testimony, and how it all comes together in a Georgia civil case. So we're going to get right into question one here. Let's start with the document that anchors almost every car accident case here in Fulton County. Why is the police accident report often one of the most important documents in a car accident claim in Atlanta?
Yeah, the main reason for that is because it is the document that the vast majority of the time is going to prove liability, meaning who was at fault for the wreck. And the reason for that is because what you're doing is you're having a police officer who jurors naturally believe they're the expert, if you will, that's coming out to get everybody's statement, including any witnesses, looking at the scene, the crumple damage to vehicles, and determining who's at fault. And so that document, very rarely does it go against the police officer, is going to say who's at fault. And that's ultimately who it typically is.
And most people have never actually read a police accident report before their own crash. What information is typically included in a police accident report in Atlanta that can affect a compensation claim?
So first and foremost, from what we just said, who's at fault? So what you get on the first page is you're going to have driver one and driver two are on the first page. If there's more drivers, there'll be a second page that has them. But there's a little box up at the top before the name of each of those drivers that says suspected at fault. And so you're looking first and foremost, which of those boxes is checked? Is it driver one? Is it driver two? Again, that is the police officer saying, this is based off of the evidence who I believe is at fault. So that's the number one thing to look for that changes compensation in a case, because again, you have to have the other party at fault. Number two is on the second page, sometimes the third page, it's going to have what's called the narrative. That is the police officer typing up, number one, most importantly, what did each driver say? So for you out there as the injury victim, it's real important to see, what did you tell the police officer as to what happened? And the other thing that's real important is, did you claim any injuries at the scene? So very often people don't have injuries right there at the scene, or they don't think they do, right? They have adrenaline going. So oftentimes what we see is driver two, who's normally the non-at-fault driver, so that would be you, the injury victim. Driver two says, has not sustained any injuries. So that's real important, because insurance companies like to grasp onto that, I believe unfairly, because again, oftentimes people don't know that they're injured and they're just being honest, and say, well, they said they weren't injured. So, all this that came up a day or two later, well, that's not related to the wreck, because they said right there to the police officer they weren't injured. So those things can be very, very important in the narrative itself. What are you saying? One, what happened? And two, are you feeling any injuries at all?
That is super helpful to directly point out where people can look for that, who's at fault on the report. So this is where a lot of people lose control of their claim without realizing it. How do insurance companies use police reports when evaluating car accident claims in Georgia?
Yeah, so what they do is what everyone does, okay? So we're doing it as well. Again, looking, who is the police officer determining is at fault? So which of those boxes is being checked? They're looking at the narrative as well. What is the officer saying? Both what both parties, their own insured, so the suspected at fault, and the injured party, what are they saying, both about what happened and, again, any injuries claimed at the scene. They're also looking, did the injury victim go to the hospital by EMS. So one of the things that's always asked, especially when you answer, yes, I do feel some pain or something like that, the officer will say, do you need an ambulance? So they're looking to see, did they decline going to the hospital? That's real important. What else are they looking for? Some more minute things that people don't realize. On the front page again, under each driver, it's a whole long section, takes up most of the page. And down toward the bottom below who's the owner of the vehicle, they're going to have different conditions. And so things like, were there skid marks? And if there were, the officer will measure how long of a skid mark. That could be important depending on what type of accident you're dealing with, and are we arguing over liability? What were the road conditions? What was the weather conditions? How fast was the person potentially going? So if he's got evidence that the person was going X miles an hour, that might make it on there. That's important because the other thing he's going to check is what was the miles per hour on that road. So a bunch of little details that you never know might come into play. So the insurance company's looking at all of this because, again, their job is to nitpick and pick things apart, right? Because 9 times out of 10, they're getting a police report that says their insured is at fault. Well, did the officer get it right? Remember, I said 9 times out of 10, whatever the officer says goes. But the insurance company's looking at, is this that 10% chance where, ooh, the officer got it wrong because I'm seeing skid marks and I'm going to make XYZ argument depending on what happened. So a lot of detail in there that the insurance company is combing through to make any and all arguments they can make against your claim.
So here's something people argue about constantly: the officer's fault opinion written into the report. Can a police officer's opinion about who is at fault influence a car accident lawsuit in Fulton County?
So the answer is yes. From what we talked about before, the vast majority of the time, what the officer says goes. They're the expert. They're, I guess best way to put it is they're the person that has no dog in the fight, right? So they're coming, they're getting both sides of the story, witnesses, any other evidence, whether there's video, any of that kind of stuff, to determine how did this wreck occur and therefore who's at fault. So it is very, very important. But what people need to know is, yes, there always is a chance the officer got it wrong. It's rare, but there are some situations where that happens. I think I talked about it on a prior podcast. My favorite example wasn't in Fulton County. It was in Chatham County down in Savannah. My client was on what they lovingly call a crotch rocket. And so naturally people are thinking someone who's on that type of motorcycle must be speeding really fast. So he's in the second of 2 lanes, and a tractor trailer is trying to make a left-hand turn across both lanes from a side street, and they have a stop sign, not a light. So they're supposed to yield and wait. Well, what ends up happening is the tractor trailer is blocking all 2 lanes, and it has the front of the tractor in the oncoming lanes of travel. My client ends up hitting the trailer and is down in the middle of the road. Well, the police report comes out because it was a chaotic scene. My guy, they thought was going to pass away. They had to life flight him. So it was real chaotic. So we kind of understood with this officer, they found my guy at fault. He couldn't speak. They missed a witness that was there, didn't get the witness statement. So they took what the tractor trailer driver said for the gospel. And the tractor trailer driver tried to say that my guy went on to oncoming traffic to try to avoid him because he was speeding and everything else, and didn't see he was already, the tractor trailer was already making the turn. And so we're getting a police report that's saying our guy's 100% at fault. He's going, well, I didn't wake up from in the hospital to 2 days later to have a ticket, a citation on my nightstand of the hospital saying I was at fault. And so we had to unpack it. We got with the witness. We then gathered all the evidence to suggest that's not the way this went down. We then talked to the officer, and he was great and admitted, talking to the witness and everything else. Yeah, I missed it. I just went off of what the tractor trailer driver said, and therefore amended his police report ultimately. So he did the right thing. But that's not your normal scenario. And again, what I want people to know from this, and I think we'll get into it here in a minute with some other topics, you never know there at the scene what kind of situation you're dealing with. So you don't want to just assume I'm not going to be found at fault. This is real straightforward. I mean, I'm telling you, even in rear end collision cases, when the person who rear ends someone else is always typically at fault, you don't want to assume. So you want to be real careful.
Yeah, that's a great example. So we have covered why the police report is so critical here in Atlanta, what is in it, how insurance companies use it, and what the officer's fault opinion really means under Georgia law. But the police report is just the starting point. So now let's talk about the evidence you gather yourself, the photos, the witnesses, the video. So the officer is human in documenting a chaotic scene, like you said, so errors happen more than people think. What should drivers do if they notice an error in the police accident report in Georgia?
Yeah, so what you want to do is, I always suggest start with a phone call to the investigating officer. So to kind of backtrack for a minute, what happens on the police report is the investigating officer drafts it up. And so his or her name will be down at the bottom as the investigating officer. What's next to that is the supervisor, who then has to review and approve the report. So to get back to your question, what happens, I always tell people, is start with the investigating officer, because they're the one that knows most of everything, right? Was there at the scene. Approach them. Obviously, phone call is the best way if you can get them on the phone, and tell them why they got it wrong. So what is it? Now, you want to come with some sort of proof if you can. So depending on what the topic is, you want to have your evidence. Hey, you got this wrong. Here's a video. Here's, a picture or something. And have a be very nice and frank conversation, and just say, I think you got this wrong. Would you be willing to amend the report, because they can amend it, to fix this error? And they'll tell you, yes, I will. No, I won't. Let me look at it. The example I gave you, they obviously at first were very skeptical and said, well, let me talk to the witness. Of course, I had a recorded witness statement from them that I gave him, and then gave him the phone number. And I said, listen, here's what I got from him. Here's the recording, but you go talk to him yourself by all means, and go from there and see if that officer will move to amend the report. If you cannot get the investigating officer, or the investigating officer says, no, I will not change it, and you are adamant that they have it wrong, and again, hopefully have some backup proof like I did in that case, you can then go to the supervisor that's on the report. Reach out to the supervisor and say, sorry, but I think your officer got this wrong. He or she's unwilling to amend it. Here's my evidence of why I think they got it wrong. I am just asking they do the right thing and create an amended report, that changes this or tells them more of what happened or whatever that scenario is. So those are the two people to try to reach out to get it changed. If they refuse to do it, there's no recourse. All you got to do is move forward and try to prove your case.
So your phone is in your pocket and the scene is right in front of you, but most people miss the photos that actually matter. So how important are photographs from the accident scene when building a compensation case in Fulton County?
Yeah, great question. And here's why, and what I want viewers to take away, why it's such a great question. What I said earlier, you're there at the scene, you've got adrenaline going, you don't know how this is going to play out. Okay. Again, 99% of the time, the other party is going to be found at fault. You're going to be okay. There's not going to be a fault argument, what we call a liability argument, but you don't know right there. You don't know if you're going to fall in that 1%, 10% realm. And so I tell people, must take any and all photographs, video that you can safely do while you're there at the scene, because you don't know what you may need later, and you want to arm your lawyer. And here's the other reason, because even if you don't have a liability fight, photographs are massively important. You know, at the end of the day, the only right you have as the injury victim is to try your case to a jury. So even when you don't have a liability fight, and so pictures aren't needed to prove who's at fault, pictures are still really good for someone like me. Why? Because you're trying to get the jury there at the scene. You're trying to bring them in to what happened. And some people learn and retain things verbally, and others do it visually. So what's great for me as the presenter is to have photographs of the scene, showing the two vehicles up against each other. Even better, showing portions of vehicles spread across the intersection, or that skid mark, you know, that's massively long, to show how fast they may have been going and that sort of thing. Just for the injury side of the case, that's great evidence. So that's why I tell people, don't just assume, oh, this was a rear end collision, they're clearly at fault. The officer's even telling me they're at fault. So I don't need to take any pictures. I don't need to worry about any of that. This is clear. This is an easy case. Yeah, it may be for liability. Most likely is. But I want to be armed with anything and everything to help persuade a jury that you should be compensated, and compensated well, for your injuries. And photographs are just such great evidence. They speak 1,000 words. They don't have to believe you and, oh, this was, you know, a big impact and here's how it hurt me and everything else. They can literally see it. And even when it's just a fender bender, as people like to call it, well, what would be great? They're going to argue, oh, it's low impact. It's just a fender bender, not a big deal. There's no way someone could have been injured. But if you're showing pictures of that car up on your bumper, that's a great picture to say, well, was it really that low of an impact? I mean, look at it there at the scene. You know, I mean, that looks like more of an impact than it really does when you see the pictures at the wrecker 2 or 3 days later, and there's just a little bump on the bumper or something like that. So you don't know what your lawyer could use to your advantage, and you only get that one shot, because you can only get scene photographs right there at the scene, and you're the only one that can do it. You're going to be reaching out to a lawyer later on, and the lawyer can't go back and recreate it. So always, always, always take as many photographs as you can before you leave the scene.
That's really great insight. And photos capture the aftermath, but witnesses capture what actually happened. So why do witness statements often play a major role in proving liability in car accident lawsuits in Georgia?
So they're real important when you have a liability fight, right? So if you're in that scenario where either the officer goes against you and you believe they got it wrong, or even more importantly, when you do have the rare kind of case where the officer can't even determine. So we have that happen from time to time. Oftentimes intersection wrecks, and it's who had the green light. You know, one's turning, one's coming straight, one's arguing they had a green arrow, they ran the red light, and vice versa. So you have a he said, she said. Obviously, witnesses are massively important there, because, again, the officer is coming and is having to make a determination just off of what are the two drivers saying and what does the physical evidence tell him or her. Sometimes it doesn't tell them anything. Having a witness say, oh, I was right behind the guy and he had a red light or a yellow, you know, where you have to caution and you have to wait and yield and that sort of thing. So witnesses can end up being the end all be all. Yes, rare cases, but again, you don't know which one you have, right? So you want to always find witnesses. And again, like photographs, I tell people, even when it's a straightforward liability case. So I know you were asking, you know, in a liability situation, but I want folks to also realize, just like with photographs, it can come up in non-liability issue cases. Having a witness that has no dog in the fight, that comes and can say things like, oh my God, I heard this massive boom. I've had some say in court, sounded like a bomb went off. And then I look over and there's these two cars, crumpled up. That kind of thing helps for the injury side of the case, which is oftentimes the entire case. So these witnesses can be really, really important. And again, you don't know while you're there at the scene what type of case you're going to have. Are you going to have a liability fight? Or are you going to need them for the injury side? So they become very important, and we got to get their information if we can.
And so cameras are everywhere now: dash cams, traffic cams, business surveillance, doorbell cameras on nearby homes. So how can video evidence like dash cams or surveillance footage impact accident claims in Atlanta?
So video is a step up from photographs, right? So when you have a liability fight, again, either in the scenario where the officer got it wrong, you believe, or more often when it's the, hey, I don't even know who's at fault, so I'm finding both at fault, video can prove who was at fault, right? Because if it captures the entire lead up through the wreck, it can be the evidence that no one can dispute, right? As you said earlier in one of your questions, officers at the end of the day, witnesses, drivers, we're all human. We could see things a little differently. We may have certain interests that has us not telling full truth, those sorts of things, right? But video doesn't lie, right? Like a photograph, it speaks 1,000 words. And to actually see it on video is huge if you're in a liability dispute. But again, I will tell people it's always helpful, because even if you don't have a liability fight, again, you can use it for the injury side, because you're able to bring people into that wreck. They don't have to believe anybody as to how it occurred or how impactful it was. They can literally watch it on the video all the way through impact. I mean, I've had videos where, you get the crash and you're seeing one of the cars go up and down. How is the other side going to argue, oh, their back injury couldn't have come from this? When you've got the video showing, oh my God, the car went up, up off its tires, so it's rare oftentimes that we have video, but the cases that we do, it's amazing evidence.
So we have covered what happened at the scene. Now let's talk about what happened to the person. What role does medical evidence play in proving injuries in a car accident case in Fulton County?
So it's everything. At the end of the day, again, it is rare that you have a liability fight. And so oftentimes these cases solely come down to what were your injuries and were they related to the wreck? And that's called causation in the law. And ultimately, the only person that can prove causation is a medical doctor. So you need to have a medical doctor who can look at the photographs, the police report, your explanation of the wreck and your injuries, and obviously the treatment that they've done with you, and say, within a reasonable degree of medical certainty, these injuries that I've treated this person for were caused by the wreck. That's massively important. It is ultimately the burden of proof, as they say, that a plaintiff has. You've got to prove that your injuries were caused by this wreck. Because what we deal with in this industry that folks don't realize, it's not straightforward. Most of these injuries could have come from a million other places, at least arguably. And that's why this is normally where the battle is with the other side, because it's so easy for them to just throw mud and say, we just don't think it came from this wreck. She might have had a little bit of pre-existing issues or things in the past. Well, we're going to just pull that and say that's where it came from. So you've got to have medical documentation and an expert most of the time to say, no, it came from the wreck and here's why.
So we have covered the evidence you can gather yourself here in Atlanta: photos, witnesses, video, and medical records. Those are the building blocks. Now let's talk about the heavyweight evidence, the experts, the reconstruction, and the technical analysis. So This is where the legal strategy gets sophisticated. Professionals brought in to analyze the evidence and explain what it means to a jury. How do lawyers use expert witnesses to strengthen accident compensation cases in Georgia?
So there's two ways. Number one, again, if you have a liability fight, it would be an accident reconstructionist that you would want to have. The other is the medical side. So whether you have liability fight or not, you're always going to have a medical fight, and you got to prove causation, that your injuries are related to the wreck. So going to the accident reconstructionist, they would be used when you have a real dogfight on liability. And oftentimes that's when you don't have video that can easily prove who is or isn't at fault, don't have witnesses, don't have photographs that make it real easy for a jury just looking at the photographs. You would have to hire this expert, and they are trained, oftentimes ex-police officers, in reconstructing a wreck. And they do it from multiple things, most importantly, simply looking at the damage to both vehicles. I've had some that have gone solely off of that. It's crazy what they can do with the technology and everything else. Now, oftentimes you want more. They'll do a scene analysis. They'll get the statements, obviously, from both drivers, what they say happened, if there are any witnesses, what they say. And they can literally scientifically recreate the wreck. If evidence is preserved right with vehicles, they can get speeds all the way down to half a second before the wreck. How fast was this car going? How fast was the other? Were they using turn signals? Were they turning the steering wheel? They can get a ton of data from that kind of stuff. So it can get very, very technical. But this person can do all of that, recreate it, show a computer model of exactly how it happened to make the argument on your behalf that the plaintiff isn't at fault, the defendant is, and here's why. Here's how the wreck actually occurred. So yeah, it gets real technical. We don't want to use them. So kind of the trial strategy that I like is you want to rarely use an accident reconstructionist. Why? Because it means you've got a problem, right? It means you have a real dogfight on liability, and you don't want that. The more you have to use experts, the more you're kind of showing the jury that, yeah, there's a real issue here, right? But they in those rare cases do become very, very helpful in trying to present to the jury, here's how the wreck actually occurred and why we believe you should find the defendant at fault.
So that kind of answers our next question. So you can kind of give another just quick summary. Accident reconstruction is the gold standard of crash analysis. How does accident reconstruction help prove what really happened in serious cases in Fulton County?
Yeah, so accident reconstructionists can really, really help. We don't, from a trial strategy standpoint, we don't want to use them unless we're just absolutely compelled, because we have no other way to competently argue to the jury to convince them that the defendant's at fault, meaning video, compelling witnesses, photographs, those sorts of things. From a trial strategy point, it's because, you know, at that juncture, you're going to get a battle of experts and things of that. They'll have an accident reconstructionist that says the exact opposite. It gets kind of crazy. But there are those cases where you have no choice. It's such a hard battle, and you don't have that other evidence potentially that you need this person. And then they get in there and they can work magic and recreate down to the second exactly how this wreck occurred in their opinion. And they can do models, they can do a beautiful video demonstration of how the wreck occurred to argue to the jury the defendant's at fault and here's why.
The damage on the vehicles tells its own story, and so how can vehicle damage reports help determine who caused the accident?
Yeah, so in those cases, and again, this is where you hope you have this so you don't have to use an accident reconstructionist. It's pretty rare, but the damage report itself plus photographs or even better, plus video, right, can sometimes tell the story. It can prove in different scenarios, no, they're wrong. Clearly, from the way this damage is to this vehicle, the only way this could have occurred is this way, right? Like the car had to been coming this angle or that angle. That disproves how that person's saying they're not at fault, that sort of thing. It is somewhat rare that alone, the damage report, would do it. But those reports are very detailed because, again, it kind of goes through every area that's damaged. Even the repair report will explain what all was repaired on it, what was damaged, that sort of thing. I actually like those reports more for the compensation injury side than I do the liability side, to be honest with you, to show how much of an impact the wreck was. Look at all the things that had to be fixed. When you're able to throw out that number, it cost $12,000 to repair this vehicle. Look at the damage report, those sorts of things. So I actually prefer it more for the compensation side than I do the liability side, but there are those cases where there's things in that report that can lead to the evidence that this person's really at fault versus the other person.
When the officer issues a citation at the scene, that citation becomes part of the evidence file. So do traffic violations documented at the scene strengthen a compensation claim in Georgia?
Yes, it does. And the main reason it does is, again, that is the expert, right? Independent expert, no dog in the fight, saying this person's at fault and I'm giving them a citation, meaning they have committed a violation of what we call the rules of the road, Georgia law, Georgia traffic law. Technically, where that becomes very helpful potentially is when the defendant pleads guilty to it, either by just paying the ticket or going and fighting it and having the judge say no, you did violate the law this way, you're guilty. You can use that guilty plea or verdict as evidence in court. And that becomes what's called under the law negligence per se. So fancy legal word, it has a statute and everything in Georgia that basically says, I don't have to do anything else to prove the defendant is at fault other than this citation, because they either pled guilty or they were found guilty after trying to fight it by the court. And that's it. That's all the evidence you technically would need. And of course, a jury naturally of normal people are going to go, okay, well, yeah, they got the citation, they paid it. What are they arguing? Like, why are they here arguing over who's at fault? And I actually had that happen. Strange enough, there's a lot of behind the scenes stuff I won't get into of why I think the defense went this way, but had a head-on collision case where the other driver was found at fault, received a citation, was found guilty, and yet they still fought liability at trial. And it was perfect, and I loved it, and it normally doesn't happen because I was able to make such a big deal out of, folks, this is why we're here. We can't even get the defendant to admit what he's already admitted to, which is this violation. They're literally here, folks, fighting us on who's at fault, much less how injured my poor guy is. And the result of that case, I think some of it was because the jury got pissed. I mean, understandably, they got upset, and that's what I was aiming for. And that's why I kept pounding on this. They came back with a $3.28 million verdict for this gentleman. Wow. And again, I think that was part of it. It was a big hit. And you mean to tell me that you can't even be a normal human being and just say, I'm at fault? I admitted it. I paid the ticket. You know, it was crazy to me. I think it was a bad trial strategy on the defense because it let me exploit it for that reason, to say this is how unreasonable they are. And the moment they don't believe you on that, they're not going to believe your arguments that my guy wasn't injured in this wreck. And so they really did a disservice to themselves. So these are these little things of where the citation can really be beneficial to you. And you never know. Again, as I keep saying throughout this thing, I hope people are realizing this is why you never want to assume something straightforward. This is an easy case, you know, all of that, because you never know. And you never know how your lawyer can use that to help you. And we were able to do that in that case. So it's a great example of how a citation can help you. And again, using that negligence per se to your advantage, even when you go all the way to a trial in front of a jury.
Yeah, that is a great example. Thank you for sharing that with us. So we talked about medical evidence proving injuries. Now let's talk about medical evidence proving what those injuries cost. What role do medical bills and treatment records play in determining compensation amounts?
So they are, in the most cases, it's the end all be all for a couple of reasons. Number one, so much of an injury case for both sides is based off of how much do you have in medical costs. And understandably, people oftentimes don't understand why, Ted, is that really the case? Why is the number, the bill amount so super important? And the reason is, again, you got to remember your only right in Georgia is to try your case to a jury and have them tell you how much your case is worth. You know, you see nowadays so much on TV and billboards. I can't stand it. Settlement. I get the biggest settlements. Yeah, most of these do settle, but you have no right to a settlement. So I tell people, you have no right to a settlement. You only have a right to the jury telling you what your case is worth. And so the bills become so important because what jurors oftentimes do, it's called priming. So you're getting, at the end of the day, one total number for the value of your case from a jury. And it's based off of partly your bills. But the bills are the only empirical number that they hear. I have 20,000 in medical bills. I have 100,000 in medical bills. Well, that starts to prime people. They hear 20 grand, 20 grand, 20 grand. They hear 100,000 over and over. And so what people often do, and you can see it on the internet when people look up, what's my case worth and all of that kind of stuff. Yes, what jurors tend to do is they go, okay, we're going to pay the 20,000 in medical costs. Now we got to give them something for pain and suffering. And oftentimes what they do is the only number they've heard is 20 grand. Okay, well, do we give the plaintiff $20,000 for pain and suffering? Match the bills. Do we give them 2 times the medical costs? 40,000 for pain and suffering, 3 times, 60, 80. So they prime off of the only empirical number that they hear. So this is what I try to tell plaintiffs, why it's so important what your bills are in this whole scenario. Now, I do think the other side, the insurance company, ultimately, they overestimate the value of a case just based off of bills. I'm real big on, and you can see it in jury verdicts that we've had, that pain and suffering is your biggest damage in a good case. They just want to go off of, oh, it's 20,000 in bills, so here's 40 grand for the entire case, move on. Well, no, it should be way more than that because of the pain and suffering. But again, yes, jurors are going to prime off of those bills. So bills become a big part of a case. Again, a good example is I have plenty of cases, especially in your concussion injury. So we're talking like traumatic brain injury type cases. Those are cases that have traditionally low bills because there isn't much you can do for most brain injuries. You can do some therapy. There is some medication that can kind of help, but the brain has to just heal itself. It is the strangest thing until you really get into it. And I've got a lot of experience, unfortunately, with my clients in these injuries. It just has to heal. And you don't know if it's going to be 6 months, a year and a half. So these cases become difficult because they're low bill, but super high, in my opinion, pain and suffering. And so how do you value it? Well, insurance is going to go, well, they only had 5 grand in bills. Well, yeah, it's because there's not much that they can do in treatment, but they suffered for a year and a half while the brain had to heal. So you mean to tell me you're only going to give them 10 grand because you're just going to do your traditional whatever? This is where the medical records then really come into play. So the other part of your question, it's the bills and the records, because the records will go through and explain what you're going through. The medical records will have a portion of it that explains what you were saying to the doctor on that day, what you were going through for the past week or 2 weeks or month in between visits. It's the documented proof of your pain and suffering, basically. And then, of course, it also has all of the diagnoses and everything else that become very, very important. What people need to realize is the medical records become evidence in the case. You can submit those, and either side will, depending on whose side it helps, submit those as evidence in the case, and the jury can literally sit there in the deliberation room and read your medical records. What were you saying? What was the doctor saying? What were your diagnoses? So it becomes the record of all of your treatment. Most importantly, what you were complaining about. And so we get into nitpicking when the defense tries to pick it apart. And one visit, you're telling the doctor, you have no more back pain. Well, did you really say that? And what did you mean by that? Did you just mean on that day? Well, they're going to take it out of context because there it is in the medical record. You had no more back pain, and try to say you're lying. So both of these bills and medical records are almost the end all be all of your injury case.
We have covered the full evidence toolkit, police reports, photos, witness, video, medical records, expert witness, accident reconstruction, vehicle damage, and traffic citations. Now let's talk about how it all comes together here in Atlanta, how lawyers build a case, how insurers fight back, and what makes the difference between settling fast and going to trial. So building a car accident case is not about one perfect piece of evidence. It is about layering until the picture is undeniable. How do lawyers combine multiple types of evidence to build a strong accident lawsuit in Georgia?
Yeah, great question. I could probably talk on this for an hour. Again, some of it for folks have to know it depends, right? So number one, do you really have a liability fight? Again, 95% of the time plus, you're not going to. So there may not be any necessity to present a full case on who is or isn't at fault. Again, a good example, even when you do, is the one I just gave you earlier about our jury trial. All I had to do was just show the citation, right? And say, folks, this is ridiculous. Here's the citation. So it depends, and every case is 100% different. But first, do we have a liability fight, and how much are we going to have to put on to convince the jury of liability? Remember what we talked about before. Is it, God forbid, the case where I have to have an accident reconstructionist? I don't want them. I don't want to have them. They're great experts, but you're always, I think, behind when you're having to use them. So do I have to put in all this evidence of accident reconstructionists and everything they did and all this technical stuff just to prove who's at fault? Because remember, that's only one part of the case. You got to prove who's at fault. Defendant's got to be at fault. But then the second one is, and it's typically the biggest one, were you injured? To what extent? And what is it worth? And so that's where most of our cases come in for trial. It's not liability. Liability is oftentimes admitted. It's fighting the injury side. Now that's where it's medical records, the bills, witnesses. So what I tell people that oftentimes I think gets missed is you want to have good before and after witnesses. What is a before and after witness? Just what it says. It is someone, and hopefully removed from just family members, that can come in and say, this is how Bob was before, and this is how Bob was after, and have a compelling story of what they saw of your life and daily life, etc. Coworkers, neighbors, best friends, are great ones. Obviously family members, the worry there is they have a dog in the fight. So how much are they, embellishing and that sort of thing because, it's the wife or the husband or whatever. But being able to tell that pain and suffering story. So the way we kind of put all that together on the injury side is it's a bunch of little things like you were kind of highlighting in your question. It's the bills, it's the records, it's before and after witnesses, it's the plaintiff themselves. They're the only ones that have gone through it. You're going to have to get up there on the stand and tell a compelling story to the jury of what all you've been through and how bad it has been, because no one has experienced, not even the doctors. Speaking of doctors, you oftentimes are going to have medical testimony. Were these injuries, doc, related to this wreck? Yes or no? What all did you do? What were the diagnoses? What was the surgery all about? You know, you have all of this. So I always look at it as the case is always about damages, always. It may or may not have an element of liability issues as well. And to what extent, who knows, depending on each case. But that's how you take all these pieces, depending on what you're dealing with, and package it together in a compelling presentation ultimately to the jury.
We started this episode talking about why the police report matters so much. And you gave a great example earlier, but what happens when it is weak, incomplete, or flat out wrong? Can a weak police report be overcome with stronger independent evidence?
Yes, it can. Intersection wreck. So again, that's typically where you get these officer shows up and you've got two drivers telling two different stories. I had the green light, you had the green light, you know, kind of a thing. It was a MARTA bus, and my client is coming downtown Atlanta, Fulton County. He is coming from a side street that has a light. Bus driver is on the main drag, and I think it was Peachtree Street, downtown Atlanta, has a light as well. And so she's going straight. My guy's waiting to turn left. He's turning. She goes through the intersection, slams into him. Big injuries. The police show and gets the he said, she said. I had green light, you had, everybody's arguing they had the green light. So officer, nothing else he can do, no witnesses. Bus was empty at the time. He writes both of them tickets. So not just both at fault, he gives them both citations and just says, go to court and argue it. I don't know who's at fault. I can't determine. So my client gets to us and I'm going, man, there's going to be video because MARTA's got probably 18 different camera views between inside and outside on a MARTA bus. I said, we got to get the video. So they wouldn't just obviously give it to us, lo and behold. So we had to file suit to then subpoena the video. Well, sure enough, the video definitively shows not only did she have the red light, literally it's in the video dash cam, there's the red light, and here she is just going, and there's my guy turning. She literally was looking like this as she's coming up to the intersection, looking out to her left, not at the light at all, which explains why she thought she had the green light, because she didn't even know. She wasn't even looking. So it definitively proved he wasn't at fault. He got his ticket dismissed, had them admit liability, no issue going forward. But we started with a police report, and understandably so for this officer, he could not make a determination. So he didn't do anything wrong. He just threw his hands up, and that's typically what happens. Now, again, we get the other, like that Savannah one, where the officer just, was probably overwhelmed and only had the driver, missed a witness, and, just went with it. And he admitted, yeah, I probably should have done better, right? Once we presented him with the witness and some of the forensics to say it really couldn't have happened any other way. So yes, you can get a bad report changed or fight it, right? Now, either one of those, so like the MARTA one, we were already, by the time we got the video, way past changing the report phase. They wouldn't change it. Again, they were just like hands off, fight it out in court, which is what we ended up doing. You may or may not get them to change it. Got to get to them as early as you can, kind of a thing, but at least can fight it. So you still can fight it, even though the report's never going to change, but here's my evidence. So yeah, it can be dealt with. It is difficult. Doesn't happen all the time, but that's why you've got to do everything you can at the scene and then get with an attorney as quickly as possible to see, do you have a fight?
The insurance company is not going to look at your evidence and just agree. They have an entire defense playbook. So how do insurance companies challenge evidence presented by accident victims?
Yeah. The biggest way they do it, because again, vast majority of the time, we're not in a liability dispute. Their biggest is on the medical side. So this is what I want people to know. It's medical, 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 medical. Everything nitpicking from the moment we talked at the beginning about police reports and what's on it and things. Did you say you were feeling any injury? Did you go by EMS when offered? They will argue all of that. You didn't say you were injured at the scene. It wasn't bad enough because you didn't go by EMS. I mean, literally, it's like death by 1,000 cuts, you know? I mean, you got to be absolutely perfect. They can fight it that way. Did you go to the hospital same day or wait 2 or 3 days? They love to fight gaps in treatment. All right. You waited too long, in their opinion, to go to the hospital for the first time or to some doctor, or you have gaps in treatment from there. So the medical is real big. Okay. They love those things. Pre-existing injuries is a huge one for them. That's almost every case, because any of us, including you, right? You're probably a lot younger than I am, but it doesn't matter at this point. They'll argue anybody's got pre-existing injuries, even when they don't have any evidence of it. That's another big one. That's the medical side. Now, of course, what we've been talking a lot about today is the liability side. Yes, they'll try to fight that. They always look for it. It's very hard. That's why most of the time in our cases, it's not a liability fight. But anything they can find on the police report, on the damage to vehicles, they may hire an accident reconstructionist. It does happen. They're going to make any viable argument that they can make, because at the end of the day, when it comes to liability, they do not have to prove the plaintiff was 100% at fault. They can win by just shaving how much the plaintiff can recover. So if they can just find something the plaintiff could have done to avoid the wreck, they're going to argue it, because they can go, I think a jury's going to say the plaintiff was 5% at fault. Okay. They could have avoided this wreck, or they could have hit their brakes sooner, or something. And I think the jury's going to put 5 or 10 or 20% on the plaintiff. Well, then your verdict gets reduced by that amount. So they will look for any of this in the police report at the scene. They're going to take photographs. They're going to look for video. They're going to do all the things we're doing for the opposite reason, to try to put some blame all the way up to 100% on the plaintiff if they can.
And not every car accident case goes to trial. In fact, most do not. Why do some cases settle quickly when strong evidence is available?
2 reasons. Number one, what you just said. When there's strong evidence, you're more likely going to get that case resolved sooner, because when there are no doubts, again, liability, no doubts. If it is a certain type of wreck or a certain type of plaintiff that there's no doubt the injuries are related. Okay, so for instance, broken bones and things like that, that's the one big category they're not really going to be able to argue, right? So what, they're walking around with a broken leg for weeks before the wreck? Come on, it obviously was from the wreck. Those will obviously settle earlier. But the other reason that people don't realize that's behind the scenes is it's all about insurance coverage. So oftentimes when cases are settling quickly, it's not a good thing for the plaintiff. It oftentimes means there's not enough insurance coverage. So like in Georgia, the state minimum is $25,000 of coverage. Nowadays, with skyrocketing medical costs, sometimes you can barely get out of the emergency room without having spent close to $25,000. So if we've got a bad wreck, good, strong evidence of liability, a low policy, and you're massively injured and you got a big ER bill alone, that case is going to settle like that. But that's not a good thing. It's because there's not enough insurance coverage. So again, getting back to what I said earlier, that drives me nuts. You see all the commercials and the billboards, and it's like, oh, settlement, fast settlement, this and that. It's all marketing. I tell people you don't necessarily want a fast settlement if you're severely injured, because it means there wasn't enough insurance coverage, and that's a bad, bad thing for you. So let it take its time does not necessarily mean it's a good thing for you.
And some cases have evidence pointing in both directions. So when evidence is disputed, how does that affect the likelihood of a trial?
Yeah, it increases the likelihood dramatically that you're going to have a trial of your case. Because again, in Georgia, we're in a comparative fault state. So you're dealing with how much of a percentage can they put on the plaintiff saves them money. And if they can get to 50%, so 50-50, think of that officer that said, I can't figure out who's at fault. So I'm going to put both of you at fault, basically saying 50-50. If a jury comes to that, then the plaintiff gets zero. You have to find 51% or more on the defendant to recover anything. And then it's a cost saving still for the defense. So anytime you've got a liability fight, especially a really deep liability fight, we're now talking, accident reconstructionists on both sides and that sort of thing, you can almost be guaranteed the thing's going to try to a jury because you can't agree on who's at fault. Therefore, how do you assess the value of the case potential? You really can't. So it's hard on the insurance company and certainly hard on the plaintiff, because the plaintiff's trying to say, I'm not at fault at all. I should receive 100% compensation. You're not going to really find common ground very often to be able to settle it without pitching it to a jury and the jury make that ultimate determination.
And Ted, last question before we wrap, and it is the one everyone wants the answer to. What are the most powerful pieces of evidence that tend to win car accident lawsuits?
So most powerful evidence is a good question. So liability side, obviously video would be number one. Number two is police officer finding the other party at fault. Those would be the two biggest for the liability side. On the medical side, it is bills, records, and doctor testimony are probably the top three. Right behind that would be your before and after witnesses, right, to show the pain and suffering side. So the first three is to prove causation. Again, what are your injuries? And they're related to the wreck. And then the bills obviously kicking in, here's how much it costs to then fix and treat all of those injuries. And then with your witnesses before and afters, hopefully really rock solid, unrelated witnesses to help tell your story of what you've been through. And then, of course, like we talked earlier, it's a combination of all of those things together, depending on how much of it you have to use, liability side most importantly, and how that then presents your case to the jury. That really is what affects the value and therefore the compensation that you would receive in your case.
Yeah, that combination point is critical. It's never just one thing. It is everything working together to tell the same story. Ted, thank you so much. You had some really engaging answers to this podcast. And so I want to let everyone know, if you have been in a car accident in Atlanta and you are not sure whether your evidence is strong enough to pursue a claim, make that call. You can find Spaulding Injury Law at spauldinginjurylaw.com or call them directly at 770-762-2932. So thank you so much for watching, and we will see you on the next episode of Spaulding Injury Law Podcast.